Good afternoon and welcome to Landmark Chambers Special Educational Needs during COVID-19 Crisis webinar. We're delighted to see so many of you join us this afternoon, and we hope that we will provide you with an interesting discussion and some food for thought. I'm Fiona Scolding, QC, and I'm chairing the session today. I'll be speaking last. I'm joined by my colleagues, both of whom are expert in this area of law, Ms. Carine, Patry and Mr. Glenister. I will formally introduce them in a moment. Just a few housekeeping points, however, to begin with. Firstly, your microphones are automatically muted and your video is automatically turned off, so you can dance around in your pants swearing if you want to. We very much welcome questions throughout the session. Please submit them at the bottom or at the top of your screen. There's a little box which says Q&A. We will be looking at them as they're coming in, and after we've given our presentation, we will be endeavouring, if at all possible, to answer some, if not all, of your questions. If we're unable to answer all of them, we will send out a written Q&A or an FAQs following on from the webinar. If you lose connection at any point, please just rejoin using the original link once more and you should be able to get back in. So without further ado, I would like to pass over to Leon, who's going to talk to us about the SEN provisions which have been put in the emergency legislation known as the Coronavirus Act 2020. Good afternoon, Leon. Thank you for joining us.
Thank you, Fiona. So what we'll start off by doing is just going through the Coronavirus Act 2020 and the impact it may have on SEN provision. The way it works is fairly simple. Section 38 and Schedule 17 of that Act permits the Secretary of State by notice to disapply or modify certain duties which would otherwise be owed, which are set out in the 2014 Act. So to take those in turn, the Secretary of State may disapply, first of all, Section 43 of the 2014 Act, which is the duty on schools to admit a child or young person if that school or other institution is named in the EHC plan, and that's mainly to cover the situation if schools are having staffing or other difficulties and are unable to admit. The Secretary of State may also disapply Section 44, which is the requirement for annual reviews. So at the moment, annual reviews can still be delivered through virtual meetings, but there may be times when staff are unavailable because of illness or other reason, and therefore even that virtual meeting is difficult or impossible. If a notice were to be issued, what I would assume and or hope is that such annual reviews would then take place once the notice period is over, so you wouldn't lose that right for another year. So they would just happen in due course. Just note though, that doesn't remove any requirement or any discretion to have an emergency review. So if a situation arises, even if Section 44 is disapplied, then you could still have that emergency review and gather everyone to discuss what should be done. So then we look at what are the duties in the Act and the 2014 Act and other legislation which can be modified. And in terms of the modification, those duties become ones not of absolute duty, but one of reasonable endeavours. Now, there are two duties which I've flagged which aren't specific to SEN but are often relevant. So the first is Section 19 of the Education Act 1996, which is often known as the failure to educate duty. So it often arises in SEN cases where a placement has broken down, for example, and parents allege that the alleged that there was some kind of delay in delivering further provision or finding a new placement. So a JR was issued under Section 19. So that is one of the duties which the Secretary of State may make a reasonable endeavours duty. The next is potentially more wide-ranging, which is school transport duties. So those are set out in sections 108A to F of the Education Act 1996. And again, those are duties which can be made reasonable endeavours. It's the last one which is probably going to cause the most concern and have the widest ranging impact, which is section 42 of the 2014 Act, which is the duty on local authorities to secure the special education provision in accordance with an EHC plan. And that will, if appropriate notice is given, that could become a reasonable endeavours duty. So all of these occur if the Secretary of State issues a notice. So let's look at the restrictions on when the Secretary of State may issue such a notice. And there are two notable constraints on that power. The first is a time limit. So any notice mustn't exceed a period of a month, although that can then be extended. Well, another notice can be issued straight away, so it can be extended, but it would only ever be in monthly increments. The second is the reasons that the Secretary of State can give when issuing a notice, and that needs to be, those reasons need to be appropriate and proportionate and must relate to coronavirus. In theory, the notice itself is challengeable, so one could judicially review that notice, but in my view, a court would give the Secretary of State a fairly wide discretion in terms of deciding whether to issue the notice or not, and there'd need to be a glaring error if such a challenge was to succeed. The appropriate and proportionate point is it mirrors Article 2, Protocol 1, so the right to education, because what the Secretary of State is doing is restricting access to education. So it probably applies, but there is a line of case law which allows the right of education to be interfered with where there are health concerns, and there's a Greek case which deals with that. So that may be relevant to any challenge. There may also be discrimination arguments because the effect of a notice would likely impact those with disability greater than those who do not have any disability. So there may be arguments there as well, but any challenge is likely to be very very difficult to do. So the question then is whether anything has been disapplied or modified yet. And the answer is no, not yet. However, note the guidance that was issued by the Department of Education on the 19th of April. It's the risk assessment guidance, which is the most important guidance on this point or in this area at this time, where it says, at present, the law in force in relation to EHC plans is unchanged, although we recognise that there will need to be some extra flexibility and are taking steps to deliver that as soon as possible. The 2020 Act includes temporary emergency powers to enable the Secretary of State, where appropriate and proportionate, to disapply or modify legal requirements under the 2014 Act. The powers have not yet been used. We are currently gathering evidence to understand the situation on the ground to inform our approach. To allow more flexibility, we also anticipate making temporary changes where appropriate to the regulations that set out some of the timescales for the EHC plan process. At the point at which the law changes, we will provide formal guidance. So a few points to pick out of that. Firstly, we get the sense potentially a notice is on its way. Whilst that may cause some concern, there is a vast array of things a notice could do. So we can't jump to conclusions yet what may or may not be done. The second point is that the Secretary of State is gathering evidence as he's right to do, and that will inform any decision as to what's necessary and appropriate. Thirdly, there is a proposal potentially to amend regulations in relation to the timescales of the EHC plan process, which for obvious reasons are perhaps more difficult to meet than in other circumstances. And lastly, just a note, there will be formal guidance if the law changes on any of this, and very likely if a notice is issued. And the importance of that guidance will be clear to you if you practice in social care, where what the Coronavirus Act did, it didn't have this notice requirement. It appeared to just change the Care Act duties overnight. But that was tempered by the guidance, which set out the situations in which local authorities could begin to relax the duties under the Care Act. And it's likely that something similar would happen in the education field as well. So what is the current situation pending there being any notice? Well, schools, we know under the guidance, are still required to allow vulnerable children to attend, which includes those with EHC plans. It doesn't include, just to note, those who have SEN but don't have a plan, or even those for whom there is an assessment pending. It's only those with EHCPs. And so under the current legislative framework, and this is what the risk guidance says in the top bullet point there, it is for parents or carers or a young person to decide whether the child or young person should continue to go to school or college. And that is because Section 42 remains in force in full. So the local authority has a duty to provide and the school has a duty to admit. There was no change to that provision, so technically the duty on the local authority to deliver still remains. But in practice, the situation is perhaps slightly different, and it goes on to say, although the duty is on a local authority and any health bodies to secure provision under a plan currently continue, in reality there may be times when it becomes very difficult to do so in practice. Decisions on how provision is delivered should be informed by relevant considerations, including staffing availability and risk assessment. So in an ideal world, what would have happened there would have been practical decisions already taken in relation to EHCPs and whether and how those are to be delivered. A risk assessment should be undertaken, and that's made clear in the guidance which I've already referred to. But things that are likely to be relevant according to the guidance are things like the health risks to the child if they attend school, particularly if there are underlying conditions. The risk is if provision isn't delivered, and also what the situation is at home. Can parents or carers deliver some of the provision, as that will likely to be relevant? And it acknowledges some instances where there may be benefits still to remain in school, for example, where the school provides personal care or health care, or whether if the child weren't at school, it would just not be sustainable to provide the provision in the plan. So a risk assessment should be undertaken. There are specific concerns in relation to residential settings, because whilst there is guidance from DfE for residential settings as to how to manage risk, if such a placement breaks down, then there is a greater concern, because often the setup at home won't be sufficient to provide the care, education and other care, which would otherwise be provided in the residential setting. But as it stands, the local authority remains with the duty to deliver the provision. And so it's on the local authority to find alternatives. In particular, it should be, in my view, considering out of county alternatives if that is required. So let's look at the situation now if a notice is issued and there becomes reasonable, the duty becomes one of reasonable endeavours. And the reality is, I think, everyone needs to be practical. Local authorities need to recognise that they genuinely need to do their best to deliver provision. And frankly, if a local authority is genuinely doing its best, it's hard to see how a court can criticise that approach. And if parents are seeking a particular means of delivering provision, then it should be on the parents to suggest that to the local authority, and there should be a dialogue as to try and deliver as much provision as possible. And I think to show the local authority is in breach, a parent would need to show that the local authority is not doing something it reasonably should be doing. So something specific that it's not doing, which is reasonable. One thing to look out for if any notice is issued is blanket policies, because those are unlikely to be reasonable. For example, we are not providing X therapy, or we are not providing something. There needs to be a case-by-case basis, in my view, and that should be considering things like remote learning, therapies remotely, personal budgets, and other means of trying to deliver provision. If the notice is issued, there will be a particular issue around those who have residential provision, because if that breaks down, or for some reason the residential provision for health reasons cannot keep students on site, then the duty will only, on the local authority, will only be that of reasonable endeavours. But in my view, again, the local authority would have to straight away consult health providers, and again consult out of county placements if that is necessary. So lastly, just to consider where the legal issues are going to be and where there might be potential areas of challenge. One is in relation to individual challenges to provision, so saying that the local authority is not using best endeavours. The second is in relation to policies and what reasonable endeavours means. There will be, I think, a lot of issues as local authorities adopt policies, both written and unwritten, as to what that means. And I think there will be a lot of letter before actions going out as to saying certain things are unlawful, and those will generate, I think, a fair amount of legal work. And lastly, there may be a potential challenge to any notice itself. I think, for the reasons I've given, a widespread challenge on that basis would be difficult, but there might be some issues around the fringes, like not taking account of certain groups, for example, those in residential settings or those who are looked after by the local authority. So there may be some litigation around that, but as it stands, we wait to see if and when a notice will be issued. So thank you very much, and I'll now hand over to Carine, who is looking at the practicalities of conducting video hearings at the moment.
Well, thank you very much indeed. Yes, this is the practical part of this discussion today. I'm not going to be teaching you any law, which is good news. I'm just going to be giving you some practical steps for SEN hearings, which are continuing to happen in the tribunal. Sorry, just trying to figure out my slides. Right, the format of my short talk is effectively in two parts. I'm going to talk you through the practical steps before the hearing, so practical steps you can take before the hearing, and practical steps during the hearing itself is going to form the second part of my talk. So we're going to start with practical steps before the hearing. How will I know how the hearing is going to be held? Now, obviously, before I even start on this slide, it's really important to understand that the tribunal is continuing to hear EHCP appeals, and it has done almost seamlessly since the start of lockdown. So these are proceeding. In fact, if I tell you personally, I've got 3 hearings this week. These things really are going ahead. Well, the FTT, the First Tier Tribunal, is continuing to hold hearings via their own video conferencing facility. So you don't need to download Zoom, Microsoft Teams or anything else. All you need is internet data connection, and they will send you a link. You will receive notification from the tribunal and a link to the relevant website. And they have effectively different hearing rooms. So the website remains the same, and then the number of the hearing room changes. They will also usually send a link which requires everyone to test whether the video link is working at about 9:30 a.m. So just prep everyone who might be involved in such a hearing to be ready to test the system to make sure it works at about 9:30 a.m. They also the tribunal also sends out a detailed note with guidance on how to conduct the hearing, and that's really important. The first time you do it, it's really important that you read that. And as I've said, you don't need to download anything special. All of the work is done for you by the tribunal itself. Now, practical steps before the hearing, what else do I need? Apart from the link, where are we with it? Well, if you only have, these are sort of practical tips for what you can do at home. If you only have the bundle electronically, which increasingly is the case, and I don't know about you, but my printer at home is terrible, so I've been trying to work entirely with electronic bundles. then having a second device or screen is really helpful. That means that you can still see everyone on screen and see the witnesses, but you can still look at the bundle or working document or anything else that you need to look at the same time. Although if you only have one screen, you're just your laptop, you can minimize the video hearing screen and simply look at the bundle, and it doesn't, you know, shut you off or do anything funny. But it is, I have found that I basically can't function now without a second screen. The second tip I'd give you is, for preparation before the hearing takes place, is that you need to set up some way of talking to the others on your team during the hearing itself. So if you need to communicate with anyone else, witnesses, clients, etc., setting up some kind of function for that is really invaluable. Some kind of WhatsApp group, email group, or something else. There is actually, a bit like on this function with the webinar, there is a chat function that allows you to chat to certain people. But the problem with that is that you can very easily accidentally message the judge. And what you really don't want to do is send a rude comment about the judge to the judge by mistake. So better to have thought in advance about how you are going to communicate with your team. I can't stress how valuable that is. And then the last tip here on this page is make sure you have a quiet room with a neutral background like us. We've all chosen something neutral, but that's pretty self-evident. Finally, on practical tips before the hearing, preparation. Now, this is probably the key thing that I want to say about preparation, is that the big difference between the old days and the new days is that you are not going to meet your witnesses or clients or other people or the other side outside court in the usual way. So the really important tip here is to schedule a conference in advance, obviously to talk to anyone that you need to talk to, but also I also find it helpful to log in to a meeting or a virtual chat of some description at about 9 AM on the day of the hearing, because there is always someone who hasn't read the bundle properly until the night before and wants to ask you some last minute questions. So schedule in, if you can, a sort of 9 AM chat with everyone you need to talk to, bearing in mind 9:30 is the time when everyone should be testing whether the link works. The working document needs to be discussed as far as possible in advance. Now, this is a real change, and I'm sure the tribunal will say in due course, it's a really positive change, they'll say, that actually people have to discuss the working document well in advance, because there is no longer any opportunity for a last-minute negotiation outside the tribunal room, which had become the norm. So as far as possible in advance, exchange copies of the working document so that you can come on the morning of the hearing with the latest version. And also that's also true of any last minute evidence. Make sure any last minute or late evidence is submitted as early as possible, because trying to email this stuff while you're trying to take part in a video hearing is really, really difficult, as you can imagine. Right, practical tips during the hearing itself. Now, perhaps the most important thing, and this is probably the most serious thing I'm going to say in this webinar, it's really, really important not to be self-congratulatory about making the technology work or to become less formal just because you're in a less formal context, i.e. your living room or your front room or your bedroom. And there's been some really interesting sort of comments on Twitter about this and articles written about this. This is still a real case about a real child, and litigants in person are just as keen as before for the case to be taken seriously. I've read some really distressing accounts of people who came along to virtual hearings and then felt like all the lawyers involved and the panel members were all sort of backslapping on the fact that they'd managed to get the technology to work. And they felt somehow they weren't listened to, and there's a real danger of that. So it's something to really bear in mind. The second sort of more practical tip is that there is a useful message or chat function, and that's really useful practically never, but it is useful if you're, for example, discussing the working document and you're trying to suggest a new form of wording that has never been suggested before. You can use the chat function to just type out suggested wording, and then all the parties can see it and look at it. And judges I've appeared in front of have found that immensely useful, because it means that you're not repeating 6 times the wording again. You've just typed it out once, everyone can see it. And much like Leon and Fiona have in the present case, mute yourself when you aren't speaking. And that's really important, because the truth is, homeworking we all know it. There are going to be interruptions and noises. I mean, my front door always rings. The doorbell always rings just as I'm about to start hearing. Just make sure that you're muted so that all of that can be avoided. Moving on to the next practical tip. Well, I mean, and these are really obvious, but I at first didn't really know how to interrupt during a hearing, because I know you shouldn't really technically be interrupting your opponent when they're speaking or a witness. But there are times where you just need to say something quite urgent, or which might, you know, cut a discussion short. The best thing to do is actually just to put up your hand. Now, it looks ridiculous, and I know we're not all back at school, but it is more effective than trying to attract attention through the chat function or talking over someone, because the disbenefit of video conferencing is that people can't talk over each other. It doesn't work. You can't just speak louder than the next person and hope to be heard. So this is a really nice way of just being able to say, I want to say something. And nobody so far has told me that it looks ridiculous, although it probably does. The second thing I'd say is that I think the hearings work really well. I've done quite a number of them now, and the judges are really on top of it now. The judges are still structured in the way that they run hearings, and the only problems I've really had are with connectivity. So it will happen. Your Wi-Fi will fail. Something will happen. Don't worry about it. Everyone knows that it will happen. There are huge demands on the internet, or you know, on various service providers during this coronavirus time. So everyone understands that there'll be times where it all goes pear-shaped. Please don't worry. And then the final thing I wanted to say on practical trips during the hearing, my biggest bug, the thing I miss the most, is not being able to talk to people, particularly the other side, but also your own client during breaks. So if it's possible, set up a way to speak to them. I mean, there's no substitute for, you know, the judge will say halfway through the hearing, I want you, you know, why can't you agree X? And then in the real world, you would go out into the outside the tribunal hearing at lunchtime, and then you would just talk to the other side and agree it. Try and find a way of speaking to the other side. I mean, if you followed my advice, you'll already have the WhatsApp group for your own people, but if you can find some way of speaking to the other side and resolving matters, lots and lots of cases settle, or lots of time is saved if you're able to communicate with the other side. So please find a way of ensuring that you can have a discussion with the other side. But the takeaway really is that these hearings are working really well. They're really important, obviously, that they continue to work as well as possible. And the tribunal has made a huge effort to make sure that these hearings, A, proceed, and B, do work well. They've got very, very good technical support. So if at any stage you are concerned about something that's happening, you can't hear, you can't do something, and then it's perfectly acceptable to say to the judge, could we just ask for some technical support? It's all in place, and good luck. I am now going to pass over to Fiona, who is going to talk to us about a very important topic, safeguarding in lockdown.
Thank you, Carine. In particular, one of my worst traits is interrupting people while they're trying to speak. So the fact that I'm going to be unable, the fact that I can no longer do so in virtual hearings is probably of great relief to everyone. I'm just going to run very quickly through some safeguarding issues which arise in particular during lockdown, which don't really arise at any other time. This is mainly an information sharing part of the talk, but I'm happy to answer any questions afterwards. So I'm going to talk about who's responsible for safeguarding children while schools are closed. I'm then going to focus upon online safety with remote learning, which is a really big issue, and we're all having to learn a lot about it. Then about the role of the school in protecting vulnerable children, and also issues to do with bullying and exploitation and abuse, which will arise more frequently during lockdown than they would do before. The first issue is just to set some background up, which is, as we all know, when schools closed, the following children were permitted to continue learning in a school setting, not necessarily their own school, but a school setting in the local area, which is anyone with an education and healthcare plan. There was a lot of criticism because obviously there are over 1 million children who don't have EHC plans but do have SEN, sometimes of a most significant nature, and those who are seen as vulnerable. Again, they were categorised as those who had a social worker. Now, we all know children who would be considered to be very vulnerable but who do not have a social worker. The government's own statistics estimates that only 5% of all vulnerable children are currently attending school. And that is a massive, massive problem, because the very reason schools were kept open was to try and provide for this particularly complicated group of children and young people with a solution to somewhere where they in fact would be safe and would be looked after. The Secretary of State wrote a letter to all schools and local authorities this week identifying this as a problem and asking that they take a special effort to keep every children in their line of sight. Now, there are some real practical issues with that, but I do think when we're thinking about things, we should try and focus on the needs of those particular individuals. The Children's Commissioner as well provided some very helpful guidance, which was on the previous slide, which I can't find. Could somebody maybe go back 2 slides, because my slides, thank you. Yeah, on the 25th of April, which in fact was Friday, the Children's Commissioner has issued some information, an information sheet called "We Are All in This Together," which is all about part of the Children's Commissioner role to try and identify and capture who's vulnerable in the local area. One of the points that she's been going on about for the past 3 years is the fact that we don't necessarily capture accurately who's at risk and where there's at risk. And the Children's Commissioner report makes quite sobering reading, identifying obviously that not just schools, but all other places where vulnerable children would usually be identified are now closed. Identifies that particularly those living in overcrowded accommodation, those who've got parents who've got drug and alcohol problems, those living in situations where there's domestic abuse, those who have to look after others, so those who are young carers, are obviously in not only in a very vulnerable situation, but are likely not to be in a school setting because they are likely to be looking after their children and looking after others. And there are also a whole load of people who don't have internet access. Now, various litigation was started about whether there should be the provision of internet access or not. The Secretary of State has issued 4G routers to be sent to children and young people who otherwise wouldn't have access to the internet. But as we all know, even if you have a 4G router, if you live in a very rural area, the likelihood of you having decent 4G reception is non-existent. So there will be a significant number of children who will not be able to have effective access to online learning. There is also, as the Children's Commissioner identified, a massive disparity between who has an EHC plan and who doesn't. The most striking example of which is if you're in Torbay, 43 of every 1,000 children have an EHC plan. If you're in Newham, 6 out of every 1,000 children, 10,000 children, sorry, not 1,000, 10,000 children have an EHC plan. So there's a massive disparity in who has an EHC plan and therefore who can access school, some of which is also linked to general areas of deprivation. So hopefully the next screen should come up. The government, shortly after lockdown started, the government produced Safeguarding in Schools guidance, which in effect says schools should, as far as they are able to, well, it says they should, keep the usual safeguarding policies and practices in place. So there should still be a designated safeguarding lead. If you're operating a cluster of schools, i.e. a number of schools coming together, then there should be a DSL, a designated safeguarding lead for that. There should be a need for online safety. All of you who are educating your children at home should have received something from your school with like an online safety policy and an e-learning policy. If you haven't had one, they're not doing their job. And basically what it says is we need to keep, as far as possible, safeguarding processes in place as they were, as if children were at school. Now, how practical that is a different option, but that's what the government's currently saying. Online safety, what's absolutely clear is that because everybody is switching to remote learning, there are a variety of different methods. In some cases, there's just work being emailed. In some cases, there's video learning. In some cases, there's telephone learning. There are a number of useful and practical resources for schools in order to enable them to run secure and safe systems. And what I've set out there is guidance which is from various organisations, which sets out some really helpful tips as to how you run remote learning in a safe and secure way. And in particular, I'd like to avert to the Children's Commissioner has a really helpful website, has a really helpful PDF to download on her website, tips and tricks for teaching using Zoom to make sure that the relevant security features are in place. There's then, I've then collated together useful online safety tips for parents. Now, as you know, I'm involved in the independent inquiry into child sexual abuse, and a lot of the evidence we received from schools in the residential schools sector and the research we've just published about safeguarding in residential schools identified that one of the main problems or gaps in the system is that parents often don't understand and aren't aware of e-safety and what's needed. So what I've done here is all of us are having to learn about how we educate our children safely. So we're all having, it's quite a steep learning curve, but there are some really useful websites out there which provide help and also provide help for children at different ages. So for example, the Think You Know website has something if your child's 4 to 7, if they're 7 to 11, if they're 11 to 14, so you can identify what the particular issues are at the particular age. The Children's Commissioner again also has a very useful guide to staying safe online written for parents and some guidance on a digital 5-a-day kit, which I personally have found quite helpful. All of the resources that I've just identified there also have guides for children written in and accessible to children themselves. In particular, my concern about online safety is twofold. Firstly, children with SEN often find using online resources amazing in terms of socialisation, but also possibly quite difficult because the unspoken rules about social communication translate across just the same to the internet age as they do face to face. And I'd recommend to everybody, the National Autistic Society have got specific resources on e-safety for those with SEN. Obviously, Leon's already talked you through the risk assessment. To be honest with you, the risk assessment guidance that the government have produced for when children should be in school and when they shouldn't is pretty basic. It basically says, think about everything and then make a decision. So I think, you know, it's not the most sophisticated, but what I would say is particularly for those who are working with children with more complex disabilities, the Council for Disabled Children has produced an absolutely excellent guide on how to manage living in effect with your child in circumstances where they would otherwise be at school when they have challenging behaviour. And I certainly think that that has been an invaluable resource, as it tells you various things like who to phone up if you need to get a doctor's appointment, who to phone up if you need to say to social services, look, I need some additional support. I should identify, as I did at the beginning, that there are a number of issues to do with supporting vulnerable children. I think a lot of this is, a lot of schools are already doing this, but really what the guidance says is do what you can as a school to try and keep in touch with these young people. So if you don't know If they're not coming to school and they should be, let social services know. The DSL should have a list of all vulnerable pupils. Please could you sort of go through that list, make sure they're okay, provide them with lunches if that's what's needed, keep in touch by email, phone or letter. I know some schools are phoning all their pupils every week to see how they are and what's going on, but not every school can do that. And as well, I should just identify that local authorities should continue to make school transport available for children to be able to attend. Now, obviously, that's particularly valuable for SEN, of course, with appropriate distancing measures in place. Things to think about, and I say this in particular because the Health Service Journal reported today that there is a 50% reduction in referrals in respect of safeguarding since lockdown has begun. And both paediatric accident and emergency units and social services and the government are really worried that children are being subject to abuse. So I would say LADOs are still there. People like Ofsted, there's been a redeployment of a lot of central government bodies like Ofsted and other bodies who are now working for local councils to produce additional support for them and to try and help them manage the process. The other issue I'm going to urge you all to think about is online bullying and peer-on-peer abuse. Pretty much everything has moved online. All children's friendships have moved even more online than they were anyway. As a parent or as a school, think about how you're going to be accessing and or stopping the kind of e-bullying and cyberbullying that we know happens. Sexual exploitation online, in particular, there will be people who are trying to use TikTok or Instagram or all those social media facilities that you've let your children have during lockdown that you had not allowed them to have beforehand. So make sure you've just got relevant parental filters in place and make sure that your children understand what's appropriate or not appropriate. What's really excellent is some of the resources that I've mentioned earlier do things like they have a little video about why you shouldn't take your clothes off in front of a camera and things like that for small children. And as well, for particularly for schools, think about criminal exploitation. You've got lots of children at home with nothing to do. The largest number of children who are trafficked in this country, in fact, come from the UK and are trafficked between one area and another for the purposes of drug dealing. So I think one of the things that everybody needs to start thinking about is the ways in which we can try and identify those group of people, because otherwise when lockdown stops, they're going to be fully formed up members of gangs. So I know there's been a number of questions come in. Thank you very much for listening to me. The first question is about, is really for Leon, which is about the regulations. And it says, what's the process for producing regulations, amending timescales, etc.? That's if they decide to amend the timescales within which an EHC assessment or an EHC plan.
Yes, so the regulations setting, well, where the timescales are all set out is in the SEND Regulations 2014. So it's not in statute. So further regulations can be made which would amend the timescales in the SEND Regulation 2014. So it wouldn't need a full-on statute, which I think was the question. But just one thing to flag which relates to that is the schedule to the Coronavirus Act, in fact, paragraph 6, sets out that the Secretary of State can, by regulations, amend the list of statutory powers that can be disapplied or modified. So it's a fairly wide-ranging power. So if necessary, the Secretary of State can make further regulations which add powers to the list, i.e. those could be modified, and then make a notice to modify them. So the timescales is a more simple point because the regulations can just be amended, but there is a sort of lurking in the Coronavirus Act quite a wide-ranging power.
Right, I think Fiona may have temporarily frozen, so I'm going to take over just for a moment. The most asked question we have is, will the slides be sent out after the meeting? And the answer is, yes, they will. We are recording the whole webinar. It will appear on the Landmark Chambers YouTube account. but it will also be, the recording and slides will be sent out tomorrow to everyone who registered for this webinar. So yes is the answer. The second question I'm going to take is one which was for me, which was about, just give me a moment, I will find it. It was about whether or not we would continue to have video conference. Here we are. Do presenters think that more tribunals will be done via video in the future after COVID-19 has passed? Could it change ways of working? Such an interesting question. It's one which in my heart, I really wish the answer was definitely not. I think it's just because I'm missing human contact, and I have to say that I don't particularly like this way of working. But the truth is, I think that there is a chance that more tribunal hearings will be done via video in the future, because if you think about the way the FTT is constituted, which requires panel members to come, sometimes 2, sometimes 3, but they have to all find their way into London, or if not in London, to wherever it is in the country, they all have to find their way to the building. Then if the case ends up adjourning, or the panel decide that evening that they can't come to the decision and they want to meet again, they all have to meet remotely in any event. So I think the tribunal may say, well, it's all worked so well that actually we will do this more regularly. I think there's a real chance of that, because it also means that litigants in person or parents don't have to travel far. They can sit in their living rooms and feel comfortable. So I think that there is a real chance actually that they will say that this is a good way of doing things. Whether or not they will completely remove, and I suppose the other thing I'd say is that the other thing that makes these tribunal hearings unusual is that they don't have public access. So there is no requirement for the public to have access and to come and sit in the back of the court, unlike most other court hearings. So they are eminently suitable for private hearings over video conference. So sadly, because it goes against what I would really want, I think they might. Leon, do you have a particular view?
Yeah, I agree with you, Carine. I was in one of the hearings I had done, and I don't know how true this is, but I had been told around now there was going to be a trial anyway in relation to video hearings, which is why the transition was so smooth. And whilst they didn't expect this many video hearings this quickly, the technology had already been set up, and many of you know that the Sen Tribunal is actually at the forefront of the whole courts and tribunal system in adopting this video technology. There are many areas where it's not been adopted at all and people are getting quite annoyed. So I think that may explain it. I also agree, Carine, that it will become more prevalent. I don't think it's going to be mandated, but it may be, for example, an option on the application form. Would you like this done by video hearing? And I know, I assume the same is true for other parts of the UK, but I know in the south of England, for example, in Hampshire, there was always a tribunal or a hearing venue in Winchester. But if you go east, you end up East Sussex, Brighton, Kent, and all of those local authorities all have to come to London for the tribunals. And it's quite a long way, and it necessitates sort of very early morning for all witnesses to come up. So I think that's right. And it also means that head teachers would have to take days out to come to tribunals, but this way they can sort of dip in and out, and they can come just for placement, for example, and dip in and out a bit more. So I think there are distinct advantages, and I think certainly will be an option going forward.
I entirely agree. Okay, I'm going to look at some other questions. There's an interesting question about transport, which I think, Leon, you and I can probably answer. If transport is normally shared, is there an expectation that this will move to solo transport in order to ensure social distancing? Do you have any particular views, Leon, or do you want me to?
I'm happy. I mean, my hunch on that is that all transport needs to be suitable under the legislation. So what suitable means is specific to the circumstance. And in this current circumstance, in terms of the government guidance, I would say that it would need to be solo. But Carine, do you have anything more to say?
Yeah, I mean, I think that's right. At the moment, that's certainly true, I think. But it depends on exactly how we come out of lockdown, doesn't it? And precisely what is said, because it's said, for example, that one of the possibilities that people will be allowed relatively quickly to use public transport again, but that they will be required to wear masks. So in any situation where social distance distances cannot be respected, that they will have to wear masks. So I don't know, it depends on precisely how it's framed in due course, sort of what the barriers which are lifted are going to be, and precisely how the guidance comes out. So yeah, I think again much will depend on where we are. I doubt that we will get specific guidance very early on it, but yeah, I agree. Right, we've also got a question. Oh, we've got quite a specific question about hearings listed. Oh, I think we've got Fiona coming back. Hearings listed in May and looking to move to July, which has already been pushed back twice. Is this likely to happen remotely? Is it bound by any time frame for completion? So I think the question really is how long is this video conferencing period likely to last for? I think that the answer is nobody knows precisely. The tribunal haven't said that video conferencing will end on a particular date. I would safely assume that if your hearing is in July, I think there's a real likelihood that it will be done remotely. I certainly have hearings which have been listed for June, where we've received a notification that it will in all likelihood be video conferencing. So I'd assume that, but everything depends, again, on precisely what happens with lockdown, what the guidance is, what the requirements are. Does anyone have a different view?
No, I agree with that. Yeah, entirely.
I think it's unlikely. I think the courts are going to be one of the last people to go back,
Yeah.
rather than one of the first. So I am not anticipating us going back live, even if there weren't to be another peak until the autumn, in reality, I suspect.
We've also got some questions about safeguarding. Fiona, maybe for you, if parents of an EHCP child are refusing to send them in and despite concerns around safeguarding and detrimental to mental health, where does the school stand?
Well, the school should make a referral to social services, most definitely. If there are issues, and the guidance is absolutely clear about that. I'm so sorry, my Q&A function, as you will have noticed, there was a slight technical difficulty, which then involved some shouting at my IT man who lives downstairs. So I apologise, but one of the things that's happened is my Q&A, so apologies for not picking that one up. You should refer it to social services. Social services should undertake an investigation. I think depending upon the nature of your relationship with the family, you may well want to approach them informally first, phone them, even maybe somebody go and visit, obviously in a socially distanced way, to see what's going on, to see what the problems are. But yes, involve social services.
Okay, there's another question about Ofsted inspections, which is an interesting one. Is it expected that when Ofsted inspections start again, they will look at this work done by schools? Can it be used in making inspection judgments on safeguarding and/or quality of education?
The answer to that is, my understanding, obviously all routine Ofsted inspections have been suspended. Emergency ones can still go ahead. I think it's highly unlikely. I think I can imagine exceptional circumstances in which an Ofsted inspection would look at what's happened during lockdown. If, for example, there had been a terrible failure in safeguarding during that time, and one for which could lay firmly at the school's door. But I think largely they're not going to look at either the quality of education or safeguarding generally during this period, because I think we all accept this isn't normal. I mean, it may well become normal, but this isn't normal, and therefore you can't be judged against something which is irregular. A bit like they're not running exams, I think everyone's going to give everybody massive amounts of latitude, although I couldn't say it would never ever be relevant, but I think it would be quite difficult to see how it could be.
I think one more. Do we have time for one more? It's really more of a point of information rather than a question. It's a really good one from Ellen. This is more of a comment, she says, but I've made a point during my presentation about how you shouldn't really use the chat function when speaking to people on your own team, and she says that she's heard reports that transcripts of Zoom chats are available to the administrator when the recorded file is downloaded, even when those which are sent privately. So she doesn't know exactly what happens with the FTT system, but it would certainly raise concerns that privileged conversations might be being recorded. And I think that's a very good point, one I hadn't thought of, and I think that's another very good reason why you should set up your own form of communication with your team, i.e. via mobile or email, rather than at any point attempting to use the chat function.
Right. Somebody else has also emailed in to say that the Ofsted have provided evidence to the Education Select Committee today, which I haven't seen, which is dealing with how Ofsted expects inspectors to look at issues during lockdown. So that's helpful. Have we got time for one more question?
Yeah.
It says we only have 50% of our children attending. All our children have EHCP. Those that aren't attending get a call every day and 2 visits a week. Should we still contact social services? I suppose the question is if you're worried about them. If you're worried about them, if you're worried about that the education they're receiving or the therapies they're receiving, that it's not appropriate, then you should be contacting social services. But obviously, particularly in placements where all the children have EHCPs, firstly, there would be circumstances in which children, when they have EHCPs, would be able to be educated safely at home. Secondly, I think there needs to be a dialogue, but I would certainly say if you're worried about children, please don't hesitate to contact social services.
There's one more actually. Should we take
Yes.
As an extension of what you were saying about Ofsted, Fiona? There was one, a concern was raised as to those who haven't done transitions, and therefore the current placement will be oversubscribed in the autumn because they've got the people who haven't done the transitions plus the new joiners.
Yes.
And the concern is whether how that will also be seen by Ofsted. I think that the short answer to the legal point is that the duty to admit will still remain unless something changes in terms of the notifications, and therefore unless there's a notice that's given. So therefore you have to admit them all. But I think the same applies, doesn't it, Fiona, in relation to Ofsted? I mean, it would be taking a practical view of these things.
Well,
about
I think the DFE, I think under section 41, if you're registered as a particular school,
yeah,
you're registered for a particular number and you're not meant to go over number. I suspect what you do is you make an application in advance explaining the circumstances and saying we need temporarily to go over number until the transition can take place, so we need to keep the children there for another term or maybe another 2 terms. I would imagine that would be looked on favourably by the DFE, and I imagine that what the DFE are going to care about is making sure that children are transitioned appropriately and safely, and so things like going over number I suspect might be less of an issue than it would be usually. Yeah. There's one more question which says there's a tension between unions and school leaders at the moment about what's expected of school staff right now, especially with the disparity between maintained and the non-maintained sector. Yes, there is, because I actually think teachers are working harder now than they ever have. I think it's an absolute nightmare if you're working in a school or a member of staff. I think it's really, really complex and difficult. I mean, my view is that school leaders have an obligation and a responsibility to children, but they also have an obligation and responsibility to staff. Now, most school leaders I know are trying to work that tension out, but I would certainly say that there should not be a superhuman expectation of you. I think we all need to manage our own expectations of each other at this particular point in time. And so therefore there should be appropriate steps taken to give people breaks, in particular if their workload has gone up considerably or they're having to cover colleagues who are unwell or having to look after children themselves. So I think it's one of those things right now. I think we're all just muddling through. If this becomes a long-term thing for 6 to 9 months, I think school leaders are going to need to put in place plans for people to have planned time off, for people to have breaks, and to work out how this works on a long-term basis. I hope that's helpful. Okay. Well, I think that's probably all that we can give you at the moment. It's just gone 5:30. Thank you all very much for joining us. Please have a lovely evening. We'll be sending out, there will be a recording of this available I think from at some point tomorrow, which will be circulated to all of you who've attended. Thank you very much for coming, and we look forward to seeing you at the next webinar. Thank you. Bye-bye.
Thank you.
Bye.